If you saw posts today saying a new law just passed and that green card rules changed overnight, do not scroll past this. Not because I want to scare you, but because the most dangerous moment for immigrants is the moment right after a headline drops, when people act before they verify. In 2026, misinformation travels faster than the Federal Register. So here is what I'm going to do for you. I'm going to explain how to verify whether something truly became law, what the reported changes would mean if implemented, who would be impacted first, and the exact steps that keep you protected even in a shifting policy environment. Welcome back to US Policy Brief. I'm Fernando. My job is to turn immigration noise into clarity you can use. This video is general information, not legal advice. If you have a complicated history, like long trips abroad, arrests, prior immigration violations, or you are currently in removal proceedings, speak with a qualified immigration attorney before taking action. Now, let's start with the most important question. What does passed today actually mean in immigration reality? People hear passed and assume it instantly changes the rules for millions of green card holders that same afternoon. Most of the time, that is not how it works. A bill may pass one chamber, but not the other. It may pass Congress, but still require a signature. It may be signed, but require implementing regulations before it changes day-to-day procedures. Or it may be an agency policy memo, which can change faster than a law, but can also be challenged or replaced. So your first protection step is verification. Go to the USCIS newsroom. Check DHS press releases. Look for a public Federal Register notice. If a claim cannot be tied to an official source, treat it as unverified until you confirm it. Now, why are green card holders hearing so much about new obligations in 2026? Because even without a single dramatic law, the system is already shifting toward what agencies call status integrity. In plain language, that means the government wants immigration status to match real-world behavior at all times, not only when you apply for citizenship or when you renew a card. Data systems are better, entry and exit records are cleaner, background checks reach further, and different agencies share information more easily. That doesn't mean you are in danger for living a normal life. It means you need to understand which habits protect you and which habits create avoidable questions. Let's talk about the specific set of reported changes people are circulating right now, because you may see the same list repeated across TikTok and WhatsApp groups. The rumor bundle usually includes 4 big ideas: a periodic status verification requirement, enhanced screening for long absences, annual reporting for certain categories of residents, and expanded look-back during citizenship review. Whether each item becomes real depends on the official text and implementation, but it is still useful to understand how these concepts work, because similar mechanisms already exist in pieces throughout immigration law. First, the idea of periodic verification. Today, most green card holders interact with USCIS only when they file something: I-90 renewal, I-751 removal of conditions, I-131 reentry permit, N-400 naturalization, or a petition for family. The concept being discussed is a system where lawful permanent residents would confirm basic information at set intervals, like every 24 months, through an online portal. The government argument is simple: keep addresses accurate, reduce fraud, and ensure that permanent residence reflects ongoing residence. The immigrant concern is also simple: missed notices, language barriers, and administrative errors could create unnecessary stress. If a periodic verification system were implemented, the practical risk would not be instant loss of your green card. The real risk would be missed deadlines. In immigration, a missed deadline can trigger a chain reaction: requests for evidence, case holds, or referral for review. That is why address management is not boring paperwork. It is compliance. If you move, file AR-11. Use USPS forwarding. Maintain access to the email you used for USCIS filings. Create a USCIS online account and monitor notices. Most problems start because people never receive the notice, not because they refuse to comply. Second, long absence travel scrutiny. This is the one most people feel already. The classic guidance is that trips under 6 months are usually smoother. Trips over 6 months can raise questions, and trips over 1 year without a re-entry permit can create serious problems. What is changing in 2026 is not the basic concept. What is changing is visibility and consistency. Because biometrics, airline data, and border systems track entry and exit patterns more accurately, officers can see your travel pattern instantly. If you travel frequently, or if you spend more time outside than inside the United States, you may look like you are living abroad and using the green card as a travel pass. That is the abandonment narrative, and it is the narrative you must avoid. If the reported 180 days in a 12-month period triggers enhanced screening becomes standardized, it would essentially formalize what many officers already do informally. Enhanced screening does not automatically mean denial. It means more questions, more waiting, and more pressure to prove ties. That is why you should travel with proof of life in the United States. Lease or mortgage, employer letter, pay stubs, tax transcript, school records for children, health insurance, and bank statements. The goal is to show the United States is your primary home, and your travel is temporary. Third, annual reporting for certain categories. This concept is often aimed at categories where eligibility depends on continuing conditions. Conditional residents already have a version of this. Marriage-based conditional residents must file I-751, and EB-5 conditional residents must file I-829. Some employment-based residents may face issues if the underlying job never existed or was fraudulent. A proposed annual confirmation for specific pathways would be a way to keep those conditions visible. If such a system exists, silence would no longer be neutral. Missing a report could be treated like non-compliance. And that is why you must know your category and your obligations. If you are a conditional resident, the lesson is immediate and real today. Do not treat I-751 or I-829 as simple renewals. They are evidence-heavy filings. If your marriage is struggling, understand the waiver options early. If your investment case is complex, keep records of job creation and project documentation. Waiting until the last minute is the reason cases collapse. Annual reporting would simply make that expectation more frequent, but the principle is the same. Document, file, and track notices. Fourth, expanded look-back during citizenship review. Here is what already exists. USCIS can review your entire immigration history when you apply for naturalization, and officers can ask about old issues, especially if they relate to good moral character, fraud, or abandonment. What often confuses people is the timeline. Eligibility for citizenship is based on 3 years for certain marriage cases and 5 years for most others. But the government can still look at earlier facts if those facts suggest misrepresentation or ineligibility. If any new law formally expands the look-back, the biggest practical impact would be on applicants with complicated travel histories, inconsistent addresses, tax problems, or questionable original green card bases. This is why citizenship is both a shield and a spotlight. Citizenship is the strongest protection long-term, but the application is a deep review. If you are eligible and your record is clean, applying is often wise. If your record has unresolved issues, file only after preparation. Get certified court dispositions for any arrest, even dismissed cases. Pull IRS tax transcripts. Confirm you filed all required returns. If you have foreign accounts, report them if required. If you had long absences, prepare a timeline and evidence of continued U.S. ties. The goal is not to hide. The goal is to be consistent and documented. Now let's address what most viral posts get wrong. They often imply that a new system means automatic cancellation. Immigration status is not usually turned off by a computer. The government uses procedures, notices, responses, hearings, and court review. Even when enforcement is aggressive, there is due process. The real danger is not the existence of rules. The real danger is ignorance of the rules and missed deadlines that convert a manageable issue into a crisis. The difference between a calm case and a nightmare case is usually organization. So what should you do right now, today, if you are a green card holder and you are hearing that new rules passed? Do 5 things. 1. Verify the source on a .gov website. 2. Check that your address is updated with USCIS. 3. Build a simple travel log with dates of departure and return. 4. Gather proof of U.S. ties in one folder. 5. If you are planning citizenship in the next 12 months, begin a pre-filing review of taxes, travel, and any criminal history. Those 5 steps protect you under almost any policy scenario because they reduce surprises. Let's go deeper on travel because it is the most common trigger of sudden problems. If you are outside the United States for 6 to 12 months, expect questions. If you are outside for 1 year or more, you usually need a re-entry permit or an SB1 returning resident visa. But the most misunderstood point is patterns. If you reset the clock by visiting for a week every 5 months while living abroad, that looks like abandonment. If your spouse and children live abroad, your job is abroad, and you do not file taxes as a resident, you are building an abandonment story. A re-entry permit helps, but it does not replace actual residence. The safest approach is to keep your life clearly based in the United States. Now let's go deeper on financial and background checks. In 2026, more systems share data. That means unpaid tickets that become warrants, suspended licenses, or unresolved criminal cases can appear during immigration checks. It also means tax inconsistencies can affect credibility. If you are a green card holder, file taxes properly every year. If you are confused, consult a tax professional. If you have a pass case, get the certified disposition. Immigration officers care about official paperwork, not your memory. This is not about living in fear. This is about living with records. Let's also talk about conditional residence and those facing marriage issues. Removal of conditions is already a delicate process. If your spouse is no longer cooperating, you may still qualify through a waiver. Good faith marriage that ended in divorce, abuse or extreme cruelty, death of the spouse, or extreme hardship. Timing matters, evidence matters, and communication with USCIS matters. If you file jointly and then separate, you may need to update USCIS and convert the case, because a joint approval after divorce can create later problems. That is not new law. That is existing reality, and it is exactly the kind of quiet risk people do not talk about until it hits them. So why do people say they are taking away rights? Often, it is because the system used to feel passive. You could live life, travel lightly, and interact with USCIS rarely. A more active compliance model feels like a loss of freedom, even if the legal rights remain the same. But the solution is not panic. The solution is adaptation. A license requires renewal. A passport requires renewal. A business requires bookkeeping. In 2026, permanent residence increasingly requires active documentation. That does not mean you will lose your status. It means you must treat your status like an asset you maintain. Here is the checklist I want you to follow for the rest of 2026. Keep your address updated. Keep your taxes filed. Keep a travel log. Keep a folder of ties. Resolve tickets quickly. Avoid criminal issues. Do not sign abandonment paperwork at the airport. Apply for a re-entry permit if needed. Prepare carefully for N400. And most importantly, do not let viral posts push you into rushed decisions. Verify first, plan second, act third. That order protects you. Let me end with reassurance. Most green card holders who live in the United States, work here, file taxes, and travel normally will not have a crisis. The law is not designed to punish honest residents living their lives. But rules and data systems are getting tighter, and that means small mistakes are detected faster. If you are prepared, those mistakes become manageable. If you are unprepared, they become expensive and stressful. Knowledge is your shield, and organization is your strategy. If this video helped you, subscribe to US Policy Brief for calm, fact-based updates. Like the video so more families find it before they make avoidable mistakes. And comment below with the topic you want next: travel, conditional green cards, citizenship preparation, or how to build proof of US residence. I'm Fernando, and I will keep tracking official updates as they publish, so you can stay protected in 2026.